Welcome back to Courtroom Chronicles, where real cases meet raw drama. Today's case dives into the estate of Earl Samuels, a family torn apart over property, probate battles, and a controversial farm sale. You'll hear claims of secret evictions, disputed ownership rights, and a judge forced to untangle a legal mess riddled with contradictions. Was the eviction lawful, or was someone's property taken without due process? Stay tuned, because this hearing has twists you won't want to miss.
Jonathan Samuels.
All right. Steve Magus, Your Honor, attorney for the personal representative of the estate of Earl Samuels, Tim Flynn.
Okay. Couple of things, and the reason that the court set this here.
Right out of the gate, notice becomes the first battleground. In eviction law, 72-hour notice is standard, basically a grace period before the sheriff enforces the order. But Jonathan argues he never got real notice since he wasn't living there at the time. The estate says otherwise. Question for you. If you were in Jonathan's shoes, would a notice taped to a door you don't live in count as fair warning?
The court officer, all of which seem to have not taken place, but the question for the court is frankly, I don't know that this writ should have issued in the fashion that it did. Maybe for not, but ultimately, but it should not. First question I have is, the documents we had indicated that the writ was executed.
Yes, Your Honor.
Okay.
Without any notice.
Well, there would have had to have been notice because there should have been 72 hours notice.
They put a notice on the house, but he knew that at the time I wasn't staying there. He knew where I was. He didn't email me or
Who knew?
Attorney Magus.
Well, all of the orders of eviction which I sign and send out, and I'm
The judge clarifies. Every eviction order he signs requires a 72-hour posting before action is taken. That safeguard exists to protect people from being blindsided. But Jonathan fires back, saying notice was deliberately withheld by the estate's attorney, who supposedly knew his real address. If true, that paints a picture of gamesmanship rather than fair dealing.
I mean, the notice on the door was dated more than 72 hours before the action that they took. So they did that, but the point is, Attorney Magus has been in communication with me about a lot of things. Deliberately didn't tell me they were doing this. He deliberately didn't tell me they were towing my cars. It's representative of how everything has gone and his lack of respect for my devisee ownership right, and the fact that I told him from the first moment I talked to him, now nearly several months ago, that buying the farm was the most important thing to me, and he's done things which have very much hurt me and my ability to follow through on that. So this is just one of, he also locked me out of the house where I was staying at the time on June 30th, my parents' house in Farmington Hills, without notice. So he has a pattern of doing things just that are easy for him.
Jonathan isn't holding back, accusing the estate's attorney of a pattern of underhanded tactics, locking him out of houses, towing cars, and ignoring his rights as an heir. These are serious accusations, but here's the bigger question. Are these examples of misconduct, or just the harsh realities of probate and eviction law colliding?
It's
There's a big story here that we could take up the rest of your afternoon, and then some with regard to the administration of Jonathan's parents' guardianship and conservatorship, and now their probate estate. I'll try to keep it on the main points that relate to this case. The property that we're talking about here has been approved for sale by the Oakland County Probate Court.
got it.
Before the probate estate of Earl Samuels was involved, a judgment was issued that advised Jonathan, I think it was the end of 2023, that any personal property that he wanted to remove from the property, he needed to remove by, I think, the 12th of December, 2023. We had several of these judgments with regard to estates and properties, okay? And I applied for orders of eviction on all of them, just to simplify the contingency that Jonathan has a pattern of anytime we try to sell a house, he says he lives there and he moves in. So I learned thereafter about there's potentially a court rule that says it has to be 56 days.
Yeah.
It wasn't that intentional. It wouldn't be the first time I've learned in real time.
Did you catch that? The attorney casually admits he's learned about court rules in real time. For most of us, that's terrifying. These aren't minor slip-ups. Procedural missteps can mean the difference between a lawful eviction and an illegal one. Probate fights often get messy, but when lawyers play catch-up with the rules, someone's rights can get trampled.
You talk, sir, but
I'm sorry, Your Honor.
going to have parties interrupting. Let me just say this, I'm not going to get into anything that the probate court does. If I wanted to be a probate court judge, I would have done it. So I'm not going to do that. All right. The issue that I have in this case, and like I said, there are a number of checks in our system.
The judge draws a clear line. Probate court decides who controls the property, not him. His focus is only the eviction order. Still, Jonathan tries to blend the two, arguing his ownership rights as an heir mean the eviction itself may have been unlawful. That's the tension here. Does heirship give him extra protection, or is this just a straightforward eviction?
Received today and reviewed that the defendant does not reside at that address. That's what I received today from, I think, the individual who is the conservator of the estate or the personal representative, which maybe means that the issue is moot, or maybe not, because, sir, you're claiming you reside there.
I'm claiming that I resided there in the past, that there's things of mine there, and that they still need to go through some process because I have rights. Because especially now that there is an estate and I'm a 50% advisee, that they can't just, without any notice, decide to try to have something enforced that's actually a totally separate action. Nearly 2 years ago, it's obviously no longer the conservatorship, and I didn't have any ownership right then. So it's, the law is actually that ownership passes at the time of death. It's just subject to administration, and then it gets backdated, sort of. So I have a legal interest that I did not have in the farm almost 2 years ago. And in fact, I told, as I say, Attorney Magdis how important it was. And he refers to me not moving things out. Well, what I told them nearly 2 years ago was I was determined that the farm wouldn't leave the family. So Dad didn't want it.
Jonathan makes a critical legal point. Ownership of property passes immediately at death, subject to estate administration. That means, in theory, he gained rights in the farm as soon as his father passed. But estates are tricky. Those rights are limited until the probate court sorts things out. Here's the million-dollar question. Do heirs truly have standing to block evictions while probate plays out?
It even has the authority to evict someone in a situation like this. Some things that I was studying today, and I actually filed something additional with the court because of my ownership interest as an advisee, that it's not even necessarily subject to the same landlord-tenant eviction procedure as Attorney Magdis had enforced inappropriately. So it's complicated. And Attorney Magdis and now my sister's attorney want it to be simple. And it's representative, as I was starting, of many things that have happened over the past 4 years. Because my parents were clear on what they wanted. My dad was clear on what he wanted for the future. And for the farm to be sold like this is horrific. And the fact that
But sir, just stop for a moment. the sale of the farm, as you're indicating, again, is not something that is
Right.
within my jurisdiction.
That was my next sentence, but your signing this order was an essential step in them selling the farm. So,
And it may very well be, but what they do with the property after an eviction, I'm not part of it. I don't know.
The judge lays it out bluntly. Even if the estate had followed the proper process, Jonathan would have faced the same timeline, 72 hours from posting. Jonathan argues he'd have had more notice before the hearing itself. But the judge isn't buying it. This shows the clash between legal time and practical time. To Jonathan, days matter. To the court, procedure rules all.
both the fact that, as you say, they didn't follow the regular rules the way they're supposed to, initiating a new proceeding if they were going to argue that eviction was the
Well, they wouldn't be required to issue a new proceeding. There would need to be a hearing prior to the issuance. But then the information that I've subsequently received may have the ultimate result of that be moot. Because the real issue is at the point, there's a time limit from the point of the judgment to the issuance of the writ, and then how long the writ then has to be executed. There are 256-day periods. Here, the first one, in terms of having a hearing, wasn't complied with. The question becomes, at least in my mind, is do I order you restored to the premises or do I not order you restored?
I would say it's simpler than that to just vacate or stay your eviction order, because there's
Can I just say this? By what you're telling me, and I don't know this for sure, but certainly the information that I received was that you were not residing at the property.
not,
Things you're saying to me right now lead me to believe that you weren't residing at the property and that there really hasn't been any harm by the execution, because you keep talking about something that has occurred as though it hasn't occurred.
no, they definitely caused harm. They already towed my vehicles. They broke into the house. They didn't give me any notice that I needed to work to remove, because they're actually, even though the house, I mean, there's things of significant value there that Attorney Magnus is not aware of.
If it's helpful, Your Honor, with regard to the substance past the procedure, he can have everything in the house. It's a hoarder house. You can't even know.
Here's a bombshell. The estate's attorney calls the property a hoarder house, saying it's dangerous to even enter. His angle? That Jonathan doesn't really want to live there, just stall the sale. But notice the strategy. By minimizing the home's condition, the estate makes Jonathan's fight look less about rights and more about obstruction. Do you buy that, or is this just another tactic?
The only property that was removed from the premises is 2 derelict vehicles that were towed and are available for Jonathan to pick up. They were
Okay, but those were on the outside. Those were on the premises, but not inside the house.
Yes.
But as far as things in the house, nothing was removed.
Nothing was removed from the property.
Correct.
Okay,
That's
that
not true.
makes it
They
easier for me.
threw things out on the front yard. They took some things. I mean, I wasn't there, but it looks like they took some things away. Because they scattered stuff on the lawn and out by the curb.
Here's what I'm going to order at this point to try to create.
The judge takes control. Because the 56-day rule wasn't followed, he sets a corrective hearing. This is unusual. It's basically a do-over after the eviction already happened. At that hearing, he'll decide one of 2 things: let the eviction stand or restore Jonathan to the property. This is the turning point. Jonathan just got a lifeline.
My determination will be whether to allow the execution of the writ to stand. And in that respect, the property inside, you can let him in or not, if that's the way I rule. Or that you would at least for a time period be restored possession of the premises subject to the hearing and then the court's issuing of a new order of eviction. And that's the best I can do to kind of remedy the circumstance. Quite frankly, it's a little bit easier than I thought because stuff hasn't been moved. So it's easier in that respect. It's also maybe easier in a certain respect. I don't think you were residing there. So it's not like I took. Sir, please.
I'm sorry, Your Honor.
It is not as though there was a, for lack of a better term, a household that then is completely taken out, and this is a different scenario. So we will have the hearing, and I will either allow the execution to stand or put it back in. That's how I'm going to handle this. And so, when's my next
The time issue though is.
I'm sorry, sir.
That I would have, if he would have followed things, I would have had more time to deal with. There's things there that would take me some time to.
This 56-day rule is key. In landlord-tenant law, a writ of eviction has to be issued and executed within strict deadlines, or the case stalls. If those deadlines pass, a hearing is required before moving forward. Here, the estate skipped that safeguard, giving Jonathan grounds to challenge. It's the kind of technicality that makes or breaks eviction battles.
Okay, just hypothetically, let's say we had gone through that whole process. And let's say they brought their $15, they brought the writ or the order of eviction in, I sign it that day. They get the officer to go out there, post it. You're going to have the same time frame. You're going to have those 72 hours prior to then the execution of the writ. So in terms of your argument regarding time, it's not an argument for the court.
Wouldn't there have been time before the hearing that I would have been notified of the upcoming hearing?
Right.
So that's the most significant time. Because
Are you listening to anything I'm saying?
I definitely am. You said that the order of the writ would be 72 hours, but I'm talking about before that, before you would potentially issue the order, the time between being notified of the hearing and actually having the hearing. And I don't know.
Okay, so here's what I'm going to do. Listen real carefully. I think counsel gets what I'm doing. I'm going to set a hearing. Normally what the hearing would have been, had it occurred in its order, would have been a determination as to issue the writ or not. I will set that hearing, although it's seemingly after the fact, there isn't much harm or any harm because I don't have a household that's displaced. What I really have is a circumstance where they've taken possession of the premises. Things have not been removed. And then I will make that determination as to whether or not that writ will stand or it will not stand. You follow that?
Yes, Your Honor. I just thought that there's requirements of notice before such a hearing.
I am about to set a date and that will be your notice.
And what would the date have been if they just started prep?
Sir, yeah, okay.
I'm
Wait,
sorry.
I'll give that to you. Hold on one moment. When they say 16? Okay, so here's what I'm gonna do. I'm gonna set it for the 16th. Okay, in person at 9 a.m. Now, we're on the 5th. So that gives you now.
Notice the judge's tone. He stresses that Jonathan wasn't truly living there, so the harm is limited. No family thrown onto the street, just personal property left behind. That distinction matters. Courts are far more sympathetic when someone's home life is uprooted. But when it's about possessions and vehicles, the emotional stakes shift. Should the law protect both equally, or is the judge right to downplay it?
Here you, that's the notice you would have gotten. Here you're getting 11 days.
Okay, Your Honor, but would that have been a hearing based on the previous filings? Because that's my basic contention
Previous filings of what?
that led to your judgment in December of 23.
I don't know what that means.
They're attempting to continue something that isn't. So I'm not sure how the procedure would work if they didn't have the December of 23 record and your.
You are truly not following this, are you?
I'm sorry, Your Honor, I'm just thinking.
No, you're creating difficulty where there is not difficulty. And you're not listening to what I'm saying. Because what I'm telling you is that on the 16th, I will make a determination as to whether or not the writ stands, or whether or not that writ is then the execution thereof is squashed and you're restored possession of the premises.
Okay, thank you, Your Honor.
That is the same decision, quite frankly, that had they filed the 56 days and it, had they filed for the hearing, that is basically the same determination that I would have been making. Could they have the writ, or do they not get the writ for whatever various reasons, may have to do something else?
What's the reference to 56 days? That's what I don't understand.
There are two 56-day periods in landlord-tenant law. First is that a judgment must issue within 56 days of its rendering. Has to be signed. The second is that a writ, well, actually, that first one isn't really necessarily a 56 day. After the judgment, the writ of restitution or order of eviction cannot issue 56 days, more than 56 days after, without a hearing. And then once that issues, that the second 56 days is that writ must then be executed within 56 days of.
Oh, it's okay. That's what I didn't understand. Okay. I thought it was a after. It's a within. Okay.
What's a within?
The 56 days that you refer to are periods within which something must occur. I thought they were periods after.
Okay, so that I'm not going to sit here and go into some huge legal argument with you.
Okay.
It's the 56 days where things can happen automatically without court intervention. Let's do it that way.
Thank you.
All right. So while that happened in this case, I am in the writ was not executed in its traditional sense because things were not removed from the premises, and I will take counsel's representation as not for the court. That has not occurred. So then the question becomes, really, just to break it down to you, make it easy. I'm going to have the hearing.
So here's where we land. Despite the eviction being carried out, the judge hits pause and sets a September 16th hearing. That hearing will determine whether Jonathan gets temporary possession restored, or whether the estate's eviction stands. This case highlights the razor-thin line between probate rights and eviction law, and how one missed deadline can open the door to reversal.
9 a.m. That will be an in-person hearing. Provide to the court whatever you wish the court to review prior to that time. And I will also review what I need to at that hearing and make my determination. Thank you,
Things
Your Honor.
will still be here, or will eventually you be in Saline?
Pardon?
Things are always going to be here, or will you eventually be in Saline?
They will always be where I am. So I am here. So we'll be here. I will let you know that on the 16th, it won't be in my courtroom, courtroom C, it'll be in courtroom A on that date. Because
Okay,
it'll be
you're always here. Some things are out of the 14A4 in Saline.
14A4 hasn't been open for almost a year now, sir.
Okay, I'm unaware of everything. I'm sorry.
Okay.
Should I prepare an order, Your Honor, or will the court Thank you.
We're good. We'll have to hear. All right,
Take
thank
care.
you.
Thank you.
Yes, it is. Good things in recess.